like to express my support and appreciation to Professor Dr. Rahmat Mohammed, the competent and dynamic Secretary General of ALCO, who honors the ILC with a working visit every year and who has significantly contributed to strengthening the cooperation between ALCO and the ILC. Furthermore, I wish to acknowledge the important contribution of ALCO to the codification and progressive development of international law through its continued support of the work of the Commission, namely by following its debates, submitting its views and suggestions, organizing meetings of experts and academics on various topics before the Commission. ALCO has worked over the years in order to ensure adequate reflection of Asian African concerns in the Commission's work. It has also urged its members to respond in a timely manner to the questionnaires sent to them by the Commission. I strongly believe that at a time when international law is facing tremendous challenges in today's world, it is of paramount importance for ALCO members to be actively involved in the formation of rules of international law that reflect their interests and concerns. Let me now turn to the topic protection of persons in the event of disasters. This is one of the most important items on the agenda of the International Law Commission. It is a subject of universal concern with a predominant human dimension. We have all witnessed the human suffering resulting from disasters occurring all over the world. For instance, in recent days, there were floods in Pakistan and in India. More recently, earthquakes in Japan, China, Iran, tsunami in Indonesia. These are just a few examples of disasters all over the world. In the face of that challenge, there is an urgent need to regulate the international community's approach and response to these dramatic situations in accordance with some key principles, the principles of solidarity and cooperation. As a result of its consideration of that topic at the last session, the Commission adopted on first reading a set of 21 draft articles together with their commentaries. These draft articles refer to the following main issues: the scope and purpose of the articles, the definition of a disaster, the duty of states to cooperate in various forms, the humanitarian principles applicable in disaster response, humanity, neutrality, and impartiality on the basis of non-discrimination, the obligation to respect human dignity and human rights, the primary role of the affected state in ensuring protection and providing disaster relief and assistance, the duty of the affected state to seek assistance and the requirement of its consent to such external assistance, the right of those responding to disasters to offer assistance to the affected state, the facilitation of external assistance and the termination of assistance, the duty of states to reduce the risk of disasters, the protection of relief personnel and their equipment and goods, and the relationship of the draft articles with special or other rules of international law. Let me quickly refer to those topics. First of all, the question of definition of disaster, you find it in Article 3. It talks about a disaster is a calamitous event or series of events resulting in widespread loss of life, great human suffering and distress, or large-scale material or environmental damage, thereby seriously disrupting the functioning of society. You might see that the Commission has emphasized the human dimension of disaster, and it has underlined that a disaster was an event that caused harm not only to individuals, but also to property and to the environment. and no distinction was drawn between various kinds of disasters, natural, human-made, or sudden creeping, or the diverse causes. Therefore, the rapporteur did not propose separate legal regimes for the different types of disasters. I may mention here the overall approach of the ILC was that in dealing with the subject, the Commission has been striking the proper balance between the need to protect the persons affected by disasters and the respect for the principle of state sovereignty and non-interference. And in order to fulfill that goal, humanitarian assistance to the persons in need should always remain neutral, objective, and never become politicized. In addition, it should be based on solidarity and cooperation between all different actors. In fact, the ILC's emphasis on rights and duties is grounded on the principle of cooperation enshrined in draft Articles 5, 5 bis, and 5 ter, and moreover, the draft extends to the response and disaster risk reduction phases of the disaster cycle, but that does not enter into the post-disaster phase insofar as it leads into development. I believe that the ILC draft fills a legal lacuna by concentrating on the basic principles that inform the rights and duties of states and other actors in the event of a disaster, and will undoubtedly provide legal support for the more detailed operational guidelines under which non-state actors, in particular the International Federation of Red Cross and Red Crescent Societies, work. Turning briefly to the humanitarian principles in disaster response, they are included in draft Article 7, namely humanity, neutrality, and impartiality on the basis of non-discrimination. These principles find wide application in international humanitarian law and are referred to in the many international instruments dealing with disaster situations, including regional ones like the 2009 African Union Convention for the Protection and Assistance of Internally Displaced Persons in Africa. The principle of human dignity, included in draft Article 5, provides the ultimate foundation of human rights law. It is referred to in the United Nations Charter, all universal human rights instruments, and most regional human rights instruments, including the 2004 revised Arab Charter on Human Rights, as well as the African and European Charters on Human Rights. Concerning the role and responsibility of the affected state towards the persons within its territory included in draft Article 12, in that regard, respect for the principles of sovereignty and non-intervention is paramount. UN General Assembly Resolution 46/182 on the strengthening of the coordination of humanitarian emergency assistance of the United Nations clearly stipulates that humanitarian assistance should be provided with the consent of the affected country and in principle on the basis of an appeal by that country. As to the primary responsibility of the affected state for providing aid and protection to the victims of disaster under draft Article 12, it is a well-recognized principle in international and regional legal instruments. It assumes, according to Article 9, the primary role of that state in controlling, facilitating, coordinating, and overseeing relief operations on its territory. This would also imply its responsibility in carrying out that role vis-à-vis the victims of the disaster. The affected state may, however, receive external assistance with its consent on the basis of cooperation with outside actors. And according to draft Article 12, it has the duty to seek assistance from states or international organizations, but only whenever a disaster exceeds its national response capacity. Draft Article 14 stipulates that the consent to external assistance by the affected state should not be withheld arbitrarily, and the Commission laid down certain guidelines for where consent could or could not be considered arbitrary. Draft Article 16 concerns the right of third parties, including states, international organizations, or non-governmental organizations, to offer assistance. It serves to acknowledge the legitimate interests of the international community to protect persons in the event of a disaster. The offer of assistance is an expression of solidarity based on the principles of humanity, neutrality, impartiality, and non-discrimination. There thus exists a complementarity between the primary responsibility of the affected state and the right of non-affected states to offer assistance. With regard to the issue as to whether a state's duty to cooperate with the affected state in disaster relief matters includes a duty on states to provide assistance when requested by the affected state, an analysis of the international practice confirms that there is currently no such legal duty, and the provision of assistance from one state to another upon the latter's request is premised on the voluntary character of the action of the assistant state. However, although there is no duty to provide assistance upon request, there may exist a duty to give due consideration to request for assistance from an affected state. On the issue of the responsibility to protect, the view was expressed during the ILC debate that the Special Rapporteur's proposals had not adequately taken into account the concept of the responsibility to protect, and this was the view of some members of the Commission. However, even if the responsibility to protect were to be recognized in the context of protection and assistance of persons in the event of disasters, its implications would be unclear. And this position was subsequently separately taken up by the United Nations Secretary General, who in his 2008 report on implementing the responsibility to protect had indicated that the responsibility to protect applies until member states decide otherwise only to the four specified crimes and violations: genocide, war crimes, ethnic cleansing, and crimes against humanity. To try to extend it to cover other calamities such as HIV/AIDS, climate change, or the response to natural disasters would undermine the 2005 consensus and stretch the concept beyond recognition or operational utility. The Commission has subsequently endorsed this position, both during its debate at its 61st session in 2009 and that held at the 63rd session in 2011. On the duty of cooperation, draft Article 8. Seen from the larger perspective of public international law, to be legally and practically effective, the duty to cooperate in the provision of disaster relief had to strike a balance between different aspects. First, such a duty could not intrude on the sovereignty of the affected state. Second, the duty concerning the assistant states relates to an obligation of conduct. Third, the duty had to be relevant and limited to disaster relief assistance by encompassing the various specific elements that normally make up cooperation on the matter. It thus covered a great diversity of technical and scientific activities. Assistant actors are required to provide assistance in compliance with the national law of the affected state in Article 15. However, the right to condition the provision of assistance on compliance with national law is not absolute. The affected state has a duty to facilitate the provision of prompt and effective assistance under its sovereign obligation to its population. States have an obligation to examine whether the applicability of certain provisions of national law must be waived in the event of disaster, like visa entry requirements, custom requirements, privileges and immunities, and so on. The duty of cooperation further implies the duty of the affected states and that of the assistant actors to consult each other with a view to determining the duration of the period of the assistance. Cooperation plays a central role in disaster relief, as I have mentioned. It has been addressed in specific terms in various UN resolutions, multilateral conventions, regional and bilateral agreements. I would just refer to the UN General Assembly Resolution 57/150 that encourages the strengthening of cooperation among states at the regional and sub-regional levels in the field of disaster preparedness and response. Article 11 also talks about the duty to reduce the risk of disasters. And the international community has recognized during the last decades the fundamental importance of the prevention of disasters, i.e. of risk reduction. The Office of the UN Coordinator of Disaster Relief was created already in 1971. And in 1987, the UN General Assembly recognized in its Resolution 42/169 the UN responsibility to promote international cooperation in the study of natural disasters and the coordination, relief, and measures of preparation and prevention, and decided to proclaim the 1990s International Decade for the Prevention of Natural Disasters. In the field of protection of persons in the event of disaster, the existence of an international legal obligation of prevention of damages is recognized by human rights law and by environmental law. And many multilateral and bilateral agreements cover the reduction of disaster risks. Article 11 includes the obligation of states to reduce the risk of disasters by taking appropriate measures through legislation and regulations to prevent, mitigate, and prepare for disasters. These measures include the conduct of risk assessment, the collection and dissemination of risk information, and the operation of early warning systems. And draft Article 10 extends the general duty to cooperate to the pre-disaster phase. I will briefly refer to what was discussed in the last session of the General Assembly this year, and this is the question of the protection of relief personnel and the equipment and goods that is referred to in Article 18. It was recognized there is a need to extend the protection to the personnel and to the equipment, and this derives from the possibility of a breakdown of law and order in the affected state during the outbreak of a disaster. And the obligation of affected states in draft Article 18 to take the necessary measures to ensure that protection is consistent with other provisions of universal, regional, and bilateral treaties dealing with natural or human-made disasters. As stated in the Special Rapporteur's 7th report, there is a requirement of consent by the state to the presence of external relief actors on its territory, and the relief personnel, equipment, and goods mentioned in that draft article should therefore be limited to those who obtain the consent of the affected state. As a general rule, however, assisting states must always abide by the principle enshrined in the UN General Assembly Resolution 46/182 of 1991, which stipulates that humanity, neutrality, and impartiality are the key principles underlying the provision of humanitarian assistance. Finally, there was a draft article, like a without prejudice clause, on the relationship of the draft articles with special or other rules of international law that was included in draft Article 20. This concerns matters related to disaster situations not regulated by the present draft articles. As an example of special rules, I may mention regional or bilateral treaties that cover disasters. As to the rules of international law, the provision mentions that they should cover disaster situations, and here I would mention the general principles of international law relating to the respect of sovereignty, territorial integrity, and political independence, for instance, and also the law of treaties, rules on responsibility of states and international organizations, rules of customary international law, and so on. They should always be observed in case the draft articles do not apply. There is one issue also which I want to mention. The Special Rapporteur also had proposed that the Charter of the United Nations should always have precedence over the draft articles. But most member states mentioned that the majority of the member states considered that there was no need for such separate provision. It was redundant because the precedence of the obligations under the United Nations Charter is universally recognized and expressly mentioned in Article 103 of the Charter itself, and needs not to be repeated each time an instrument refers to an obligation under international law. Should the draft articles later be adopted as a convention, then the preamble of this convention could include a reference to the provisions of the UN Charter as it has been the practice in other situations. Let me very briefly refer to some concerns expressed by ALCO members, whether in meetings of ALCOs or in the Sixth Committee of the United Nations. And these concerns refer to if the draft articles affect the question of the sovereignty of the affected state or the consent, the necessary consent of the affected state to external assistance. I would clarify that this has been taken care of in a number of articles. For instance, in Article 4 on the use of terms, it mentions that assisting states or other assisting actors provide assistance to the affected states at its request or with its consent. This is very explicit. Article 12, role of the affected state. It mentions that the affected states, by virtue of its sovereignty, has the duty to ensure protection of its persons and provision of disaster relief, and has a primary role in coordination. Article 14, consent of the affected state to external assistance. There's always a requirement of consent in the provision of external assistance to the affected state. Article 15, conditions on the provisions of external assistance. The affected states may place conditions on the provision of affected states according to its national law. And also when it comes to in Article 4, in use of terms regarding the relevant non-governmental organizations, it mentions that those non-governmental organizations providing assistance to the affected states at its request or with its consent. So I think these clarifications might dispel some of the concerns relating to the issues of consent and the sovereignty of the affected states. But in the final analysis, I want to mention that the whole draft article is based on the principles of solidarity and cooperation more than anything else. Finally, at the last session of the ILC, after consideration of the topic, the Commission adopted, as I mentioned, on first reading, the set of 21 draft articles and its commentaries, and then it decided to transmit the draft articles through the Secretary General of the United Nations to governments, competent international organizations, the International Committee of the Red Cross, and the International Federation of the Red Cross and Red Crescent Societies for comments and observations, with the request that they be submitted to the Secretary General by the 1st of January 2016. So not this coming January, the following one. So this will give ample time, I think, to ALCO members to reflect and to prepare their comments and observations. In my view, the support of ALCO members to the ILC draft articles with their comments and observations will be essential for the successful completion of the ILC work on this important subject by the end of the Commission's current mandate that expires in 2016. Thank you.